At the start of the 2022-2023 school year, Montgomery County Public School System began introducing LGBTQ inclusive books as required reading in its elementary schools. Initially, the county school board allowed parents to opt out their children, but in the middle of the school year, the county rescinded the policy. In response, 3 religious organizations sued the county for a violation of religious liberty, citing Wisconsin v. Yoder, which held that a parent has the right, a constitutional right, to guide the religious future and education of their children. In yesterday's hearing, several of the justices focused on the fact that the books in question were not part of the human sexuality classes where opt-outs are still permitted, but rather the English curriculum for as young as pre-kindergarten. And they also noted that human sexuality classes are not even introduced until 4th grade. Mark, is there a distinction between the desire to make schools a safe place for LGBTQ plus children and the desire to use elementary schools to implement liberal social ideology?
Well, this really is a very tough balancing act. I think it was easier when you referenced the fact that when it was sex education, it was a little easier to create a carve out. It is very much more difficult for the courts to try and get into the business of figuring out what's part of the curriculum and what's not a part of the curriculum. I think this really underscores the fact that it's hard to have an educational system that is sort of one size fits all, and that that's a challenge in a large school district like Montgomery County's.
So, Mike, Justice Kavanaugh, who's a lifelong resident of Montgomery County, but admittedly did not attend public schools and did not send his children to public schools, but is a fairly reasonable person, said at one point, well,
that's probably a debatable head, but we can come back to that later in the program.
At one point, he said, I guess I'm mystified at how it came to this. So how did we get to this point?
I think one of the real challenges, and Mark kind of alluded to this, we have representatives of every country in the world in Montgomery County. We have people from all walks of life. And I think when you're trying to create a system that it can begin to teach and expose children to the things that they're going to see every day in school, you're trying to come up with ways to build that into your curriculum because that's just what exists. We have everybody. We have 160,000 students, and you're trying to be able to demonstrate how to be respectful and civil to the different types of people that you're liable to come across in the course of the day in your school year in Montgomery County. And so I'm not surprised that Justice Kavanaugh doesn't understand how we got here, because Georgetown Prep doesn't look like that. And so, and that's, and
that's fair. But the question really is, where does the line between advocacy and teaching tolerance blur? Have we crossed that line?
But I guess there's an assumption implicit in what you're saying that what people are trying to do is to advocate for something. And I don't believe that it's an element of advocacy that they're doing. I think that what they're trying to do is, in the course of written material that they're teaching children from, is to be able to take the written material, to be able to help them read better or help them read at all, and then to be able to have that correlate to the things that they're seeing in their everyday life. And I think that that is a very challenging needle to thread when you have as much diversity as we do in this community. And so I think that's the challenge. And I think Mark said it right. That's a really hard needle to thread.
So Mark, going back to this whole concept, I think that part of the issue that affects the plaintiffs in this lawsuit was the age appropriateness of the teaching material, and the fact that it doesn't belong in the English curriculum. It belongs in human sexuality, and they should be. And the current policy is that you can opt out on human sexuality as a parent and have some rights and control over what your children are exposed to. You get the last word on this.
Well, I was going to say, as you've established, that principle has been long established. It's the problem. The issue is do the courts really want to get into having to pick and choose the details of the rest of the curriculum? And it's I think one of the reasons why the plaintiffs in this case lost at the district and at the Court of Appeals level. It was very interesting the Supreme Court took up this case because it is very difficult to make those distinctions.
Well, there's another Supreme Court case coming up next week that also deals with education, And it, it's the Drummond case, and it may, change things even more radically than the narrow decision regarding whether one should be able to opt out or not. So, Mike, you have any final thoughts before we go to the next topic? I'm sorry.
No, that's okay. I applaud the MCPS for trying to figure out how to engage as many of its students as possible, but it is a very challenging thing to do in a school system the size of ours. And I think, and I hope that the Supreme Court can take those elements into account. And I think Mark has raised a really good point that, do you really want to be in the decision-making business for curriculum of school systems?
Well, the justices even talked about that. What's the slippery slope with respect to this decision? And, you make one decision at this level, and then how are the lower courts going to interpret it and apply it? So it's going to be, you're right, it's going to be a tricky solution.